Good morning, Chief Justice.
How are you this morning?
I'm doing fine, thanks, and you?
Thank you very much. I'm doing fine, and all the commissioners are doing fine too.
Thank you, Chief Justice.
Thank you very much for availing yourself for this interview for a position in the Supreme Court of Appeal. I will ask you questions, and the commissioners will ask you questions. Our questions are all directed at seeing how you fare when we look at your information and compare it with the selection criteria that we have adopted for the selection of judges. And we may be robust in the questions we put to you, but we don't mean to humiliate you in any way. We will treat you with courtesy and respect. We just want to make sure that we have enough information after the interview to be able to assess whether we should advise the President that he should appoint you to the Supreme Court of Appeal. Okay.
Thank you, Chief Justice.
Okay, let's start. You hold 3 degrees, BProc, LLB, and LLM, is that correct?
That is correct, Chief Justice.
And you got the BProc from the University of the North, as it was called then, and the LLB from the University of Free State, as well as your LLM from the same university. Is that right?
Indeed, Chief Justice.
Yes. And I see that your first encounter with law after university was as a judge's researcher in the SCA.
Indeed, Chief Justice.
That was 1996.
That was 1996, 23 years at the time.
Yes. And thereafter you went to do articles.
Indeed.
Is that right?
That is correct, Chief
Yes.
Justice.
And you were admitted as an attorney when?
I was admitted as an attorney about 1999.
Okay. And how many years did you practice as an attorney before you were appointed as a judge?
Having started in 1999, it would have been about just about 11 years or so.
About 11 years. And you were appointed to the Northern Cape Division.
Indeed, Chief Justice.
Which is where you still are.
Which is where I am still currently.
Yes. So that means you have, and you were appointed, which year were you appointed as a judge?
I was appointed as a judge in May 2011, but I started acting from January 2010, the 25th of January 2010.
So you have been a judge for about 11 years?
I've been a judge for about 13 years, and if we take it to January 2024, that is in 3 months' time, it would have been a period of 14 years. So at the moment, it's 13 years, just about 10 months.
And 14 years sounds good.
Sounds very good.
Yeah. Now, have you in the Northern Cape Division? How diverse is the work that you are exposed to as a judge in terms of cases that come before judges in that division?
Quite a diverse fields of the law, Chief Justice, family law, commercial law that we get to deal with. Here and there you would get one dispute in maritime law because, Northern Cape, we also have the SC there, but we don't often get to do those cases. But almost everything, Chief Justice, criminal work that we get to do. As I said, commercial law, contracts that we have to deal with. Yeah, it's wide-ranging field.
Yes. You were then appointed as Deputy Judge President, is that correct?
Indeed, Chief Justice.
Which year was that?
I was appointed the Deputy Judge President in 2001. I can't remember the precise date, but it was in
2001?
2021, rather. I beg your pardon. 2021. Yeah, one gets confused these days with the 2000s and the 2021s. Yes, 2021.
Okay. All right. How did you find that leadership position?
Well, Chief Justice, I was appointed in 2021, but I've been executing that particular function from 2017, which makes it 6 years. So one can safely say that at the moment I have been in that position for a period of 6 years. Both in my court where I was appointed Northern Cape, and as well as the Labour Court for a period of 6 years, although effectively I was appointed in the position in 2021.
Yes.
And the experience, coming back to the question, it's been quite a good experience. I've been in a leadership position. I've been a leader before I came onto the bench, having been a director in a law firm. So it was not really a difficulty in interfacing and dealing with matters at an administrative level.
Yes. Did you get appointed as a judge of the Labour Appeal Court, or did you only act as a judge of that court?
I've acted as a judge of the Labour Court in 2015, and subsequent to that, I think from 2016 on ad hoc basis, I've been acting as the judge of the LAC. And on ad hoc basis here and there, I would also act there as the deputy judge president of the Labour courts. And
how did you find sitting in the Labour Court and sitting in the Labour Appeal Court?
Well, sitting in the Labour Court, it was quite an experience at an appellate level, and more intriguingly or interestingly, I would sit as a presider at that level. And this is how it came about with my appointment as the acting judge president, or alternatively the acting DJP in that court. I would then have to preside over matters in that court and preside with very senior judges on my bench, Judge Dennis Davis, for one, Judge John Murphy, and Judge Sutherland, Philip Coppin, and others, and one gains a lot of experience from these legal giants. So it was really a very engaging type of an experience with the judges, and I found it quite enlightening.
And have you had a chance to act in the Supreme Court of Appeal?
Indeed, Chief Justice, I have.
How many stints have you done?
In the period 2021, just shortly after my appointment as the Judge President of the Northern Cape, I was invited to act in the SCA. It was for a period of 3 terms in 2021, and in 2022 I acted there for a term. So effectively that makes it a period of a year.
Yeah.
Yeah.
And how did you find the experience?
The experience was similarly quite enlightening. You get to engage with colleagues there. They get to encourage you. They appreciate the type of work that you're doing in the court. I mean, majority of colleagues were really pleased with the work that I have done in that court through my engagement with them, and the debates were stimulating, really, in when it comes to post-hearing conferences with the judges, and even afterwards, just on a social level, it has been quite good.
Well, I should have remembered that you have acted in the Supreme Court of Appeal, because the Concord dealt with a matter that in which you had written a judgment when you were acting in the Supreme Court of Appeal. You know which matter I'm talking about?
I know, Chief Justice, and the decision of the Constitutional Court.
You liked it?
I very much so. Although it was a split decision, but very much in favor of or confirmed our decision in the SCA. I enjoyed reading the judgment. I had not mentioned it in the papers. Because when the judgment of the Constitutional Court was delivered, we had already submitted our papers. But there's also another judgment which I think came before the SCA.
Well, let's be complete in case somebody is interested in that judgment. There's Fujitsu. But you were nearly not upheld because it was 4-5.
4-5.
Yes, okay, you wanted to say something about another judgment?
There was also another judgment that came before the Constitutional Court, but then an order was made really dismissing the appeal. It's also one of the judgments that I penned when I was in the Supreme Court of Appeal. Yeah.
Okay, now that's good. Now, tell me, in the High Court, in the Northern Cape, have you had exposure to dealing with cases where you are required to determine the constitutional validity of legislation?
Of legislation.
Yeah.
Chief Justice, I have not specifically dealt with a matter that requires that legislation or conduct that is in conflict with the Constitution be declared constitutionally invalid. But I remember that at the time when I was still very fresh on the bench in 2012, I got to deal with a matter where they had required me to declare a constitutionally invalid regulation. I mean, it's a subordinate legislation. So I had to do a quick research on that at that time. And having gone through I think at the time it was the Constitutional Court Complementary Act of 1995, before the promulgation of the Superior Courts Act. I had then established also reading that with Section 167, that really one cannot really declare a subordinate legislation, it does not have to be confirmed, the declaration of constitutionality of subordinate legislation, only to that extent.
Was it regulations?
It was regulations, yes, regulations pertaining to the registration of private schools, in particular Regulation 2 but it's a provincial regulation as well that I'm referring to.
And in the Supreme Court of Appeal, you also didn't get that opportunity?
Not at the Supreme Court of Appeal.
Yes. Of course, part of the reason why maybe the Supreme Court of Appeal, you might not have got the opportunity, is that those matters tend to go straight to the Constitutional Court after the High Court. But let me ask you another question. Are you familiar with two types of discretion in law? And if you are you able to tell the commissioners what the difference is between those two types of discretion and what this legal significance is of the distinction between the two?
Hi, thank you, Chief Justice. When a lower court exercises a discretion, it's either a discretion in a narrow sense or so-called strict sense, and a discretion in also called narrow sense or true sense, and we also have a discretion in a wider sense or loose sense. What this helps us with as sitting as appellate court is to determine the standard of our interference with that discretion. In fact, the position there was reaffirmed in the decision of Trencon by Justice Hampepe on delineating the distinction between the two. We know that also Knox de Aki, back in the years, the AD decision dealt with this, but it's that position, the distinction itself, it's clarified in Trencon. Basically what this means is that when a lower court exercises a narrow discretion, a discretion in a true sense, it means that there are limited powers of interference on appeal with that discretion, because the lower court would be having a penalty, if I have to put it that way, of options to consider in exercising a discretion. Take, for instance, the issue of costs. The lower court has a discretion to award costs on party scale, on attorney and client scale. Our powers on appeal are quite limited. We cannot just replace the discretion simply because we would have preferred it to have been exercised in a particular way. So our powers of interference there are limited. Then again, we also have a discretion in a wide sense where we would be more justified in interfering as an appellate court with the discretion so exercised in a wide sense as an appellate court. But again, I need to also caution that we are not at liberty just to interfere with a discretion. One has to be slow. One has to be satisfied that this discretion was really not regularly or properly exercised for the court to really interfere, really honestly in both cases. That would be the standard.
Yeah, is that the narrow discretion?
The narrow discretion, yes.
What is the position with the wider discretion?
The appellate court would have the authority to, the discretion in a wide sense, an appellate court will be having the power to interfere with the discretion, provided the discretion was improperly or capriciously taken in that sense.
So what is the difference between the two?
The limited power in one of interference, and the other is, though we may not interfere, we may substitute at some point if we believe that the discretion was improperly carried out.
And on the narrow discretion, if
it's quite limited.
If it was improperly exercised, you Can you not interfere?
You can still.
I'm trying to see the distinction between
Yes,
the two.
it's always,
as you understand
there's
it.
that, yes, it's always, there's that fine line, but you still interfere. If the discretion was not properly exercised in a case of a narrow discretion, you still have to interfere, Chief Justice. Take, for example, the issue of cost. If the judge had made a cost order in a situation where clearly the discretion was wrongly taken, it should not have been without consideration of the law. Particularly, let's say maybe it was a case where BioWatch was applicable and the court there closed its mind to the applicability of BioWatch. You would definitely have to interfere as an appellate court, even though it's a narrow discretion. But as I said, limited power of interference there. Where sometimes
So
the court does not even
one,
exercise a discretion at all, Chief Justice, when it was supposed to have exercised its discretion in a narrow sense.
The other discretion, the wider one?
The Court of Appeal can go to the point of substituting the decision that was taken.
Under what circumstances, or as it sees fit?
In a wide sense, the court is limited, that is the lower court, when it exercises a discretion, it's limited within, there is not so many options available to it within which it can exercise a discretion, as opposed to the other, as opposed in a case of a narrow discretion. So in this case, an appellate court would be very much be at large, whereas in the other one, the appellate court is not so much at large to interfere.
I will now give the opportunity to the Deputy President of the SA to put questions. Thank you.
Thank you, Chief Justice. Good day, Judge Phatshoane.
Good day, DP.
You were appointed to your current position following your interview in April 2021.
Indeed, DP.
And you finally got it after third or fourth attempt?
Indeed, DP.
Which one? After 3 or 4 attempts?
I think it was after 3 attempts and the 4th one.
You got it. You
yes,
got the note.
Yes, I got the note.
And the 3 occasions prior to that, you were pitted against one of your colleagues in the Northern Cape High Court.
Yes, I think on 2 occasions.
On 2 occasions. And that colleague is no longer in that division. After your appointment, she sought a transfer to the Eastern Cape.
She did get a transfer to the Eastern Cape.
I want now to take you to paragraph 16.1 of the questionnaire. Which is at paginated page 11.
Right, DP?
You have listed therein cases which you regard as most significant.
Right, DP.
And you provide your reason why you thought them to be most significant in an annexure. It's annexure F, which commences at page 20.
Right, DP.
And I had occasion to randomly pick up on some of those judgments, which in my view were the type of cases, run-of-the-mill type of case, where there was a precedent and the law, in fact, well settled. Perhaps it would be helpful for me to point out which one are those. We start with Bayport, where there was the Constitutional Court precedent of Nkata and FNB, and the second one, Canton Trading, which was essentially a matter of question of interpretation, where the principles are well settled. And then the one at page 25, ESCOM, where the Litsimeng local municipality had relied on a defense of impossibility of performance. And even there, the case, I think it's Harris versus King Williamstown Municipality, decided that issue a long time ago, more than 6-7 decades. And then Shenga, South Africa, similarly, a question of interpretation of an insurance policy. What is your response to what I've put to you?
Thank you, DP. Some of the decisions, the legal position one might argue that has been well established, and some of the decisions one would say not so. In fact, the first matter, the Bayport securitization, and another versus University of Stellenbosch Law Clinic, Nkata matter dealt with entirely a different section of the National Credit Act. Here we were asked to interpret Section 101 of the National Credit Act, and Section 103(5) thereof. It has not been dealt with in any court before. It came for the first time before us, and it is a matter of national importance. And I say this because it deals with the question of what are collection costs. Do collection costs equate to the cost of litigation? Collection costs are referred to in Section 101 of the National Credit Act, including interest, fees, and
Will you please switch on your microphone? Thank you.
The argument by the Law Society in that case was that the legal fees were not collection costs as referred to in that section. And I will tell you, Commissioner, the reason why the respondents in that case would have wished that collection or the legal fees be part of the collection cost. If one reads Section 103(5) of the National Credit Act, it would say that the cost of credit, in other words, the collection costs, the interest, default administrative charges, that section says that they may not exceed the unpaid balance of the principal debt. In other words, the collection costs cannot exceed that amount. And what about legal fees or legal costs? Is there a statutory cap on the legal fees? So the argument was that there was a statutory cap on the legal fees. In other words, attorneys, advocates cannot charge any amount that's more than the unpaid balance of the capital that's being owed. So it's a matter of national importance in the sense that we had to interpret that section. Does the collection cost referred to in that section 101 really include the legal fees? And our conclusion was that the collection costs would not include the legal fees. And commissioners would know that once a statute must be interpreted so as not to alter the common law. And unless the statute itself expressly says that common law has to be altered. In this case, there was a 1916 AD decision where a D and DH Waller decision where the appellate division at that stage did not, although not under the National Credit Act, did clarify that collection costs are collection costs, but the legal costs are something different. When an attorney goes out to defend a matter and is awarded costs afterwards, those costs cannot be equated to collection costs. So DP, I would like to differ. That matter, Bayport, is of national importance. It deals with the most important issue, collection costs and legal fees. One would imagine if that section was to be interpreted to say that the legal fees were kept, what the consequences of that would be. It would mean that the courts cannot exercise their narrow discretion at all when it comes to awarding costs, because there would have been that cap that's introduced by Section 103(5) of the National Credit Act, and it does have some implication in that regard. And the content trading, I cannot say that it's a matter of national importance, but it does bring some clarity on what has to happen in an event that where parties had concluded an arbitration and there's a clause in the arbitration agreement which to the effect that the dispute must be determined by the arbitrator, and the parties dispute the very same agreement that they had not concluded agreement. What has to happen in that case? Are the parties entitled to approach the court to resolve the impasse, or what has to happen? Should the arbitrator himself determine his own jurisdiction? To that point, I think that matter is important in that it brings clarity, and from the majority decision, there's a concept which has never featured anywhere in our law in South Africa that's been introduced by that Dutch that judgment, the so-called competence jurisdiction, which is from the German law. So I would say that matter as well, it has some significance out there. And by the way, I have penned a dissenting judgment in that Canton trading matter, and on the very same issue of the arbitration, what happens when the arbitration rules provides that the arbitrator can determine his or her own jurisdiction. Do the parties have to go to the court or not in that instance? So I think it has some importance there. The Director of Public Prosecution, Mukadi, yes, it deals with a matter which I would not say is noble, but the other judgments that I have attached there, the South African Airways Limited in business rescue is definitely a matter of public importance. There's a judgment which I penned when I was sitting in the LAC concerning the interpretation of Section 136 of the New Companies Act. What has to happen in cases of business rescue? It brings clarity to the South Africans there. In cases of a retrenchment exercise, does it have to be proceeded with without the business rescue plan, or the business rescue practitioner ought to have a plan in place before it proceeds with the business rescue? And by the way, there were 3 conflicting decisions from the Labour Court on that, and we had to clarify that position. So I believe that that is a matter of national importance, and it drew public interest, if I may so say. And the matter of National Director of Public Prosecution versus Scholes, we also know that it also drew public interest. It was followed well by the media. The Minister of Higher Education and Training, it's about the repository of power that's constrained by the principle of legality. Is about the checks and balances that the judiciary, or the role that the judiciary has to play in the checks and balance within the principle of the separation of powers. Well, the principles there are well established, but in that case, I had dealt with what would be the meaning of consultation when the act is to the effect that the minister would have to consult.
May I interrupt you, Judge
Yes.
Phatshoane?
Thank you.
Please try and not make your answers too long.
Right.
I think what is required is the gist only of the principle.
Yes, the gist of the principle. I think I've covered most of the matters, because I understood the question to be that they do not deal with matters that are significant. So I had thought I was highlighting the significance.
It's legal significance that is
True, yes.
being asked for.
Yeah.
It's legal significance.
Yes.
So you go to legal principles. Why is this case important? It's unlikely to be the facts. It's not the
Yes.
facts. Yeah.
Yes, as I said, in the South African Airways, it's about the interpretation of the legal significance lies in the interpretation of Section 136 of the Companies Act, and the National Director of Public Prosecution. I wouldn't say that.
In fact, sorry to interrupt you,
Right.
Judge Phatshoane. I identified the cases, and those that you are now addressing were not amongst the few that I identified. So you have provided your response to what I put to you.
Thank you, dear DP.
Thank you. Okay, so you were recommended to your current position in April 2021. April 2021 to November 2021, you were at the SCA.
That's correct, DP.
From there, you went to act in the Labor Court or Labor Appeal Court?
From which period, DP?
From the SCA. You were with the SCA until the end of November.
Right. I cannot recall that I had acted in the labor. I might have. I mean, I've acted in the labor court on ad hoc basis.
From January 2022.
But from the SCA, I don't think that I went to the LAC at all.
Because the date I have here from January 2022, you acted.
Yes, that was before the Supreme Court of Appeal. The stint in the Supreme Court of Appeal in 2022, I think, was around April.
Yes, April to end of May 2022.
Indeed, yes. So the stints at the Labor Court were prior to my acting.
And the period prior to that, you acted as DJP in the Labor Court.
Yes, but prior to that, yes.
Yes.
Indeed.
I know that the JSC has consistently lamented the fact that out of 13 courts in the country, only 3 are headed by women judges. If you were recommended for the position that you aspire to, would it not be a setback for the commission?
DP, I do not think that it should be taken as a setback for the Commission. It should be taken as a gain for the Commission. And I say this for the following reasons. I have been acting in this position for a period of 6 years. Perhaps maybe I should take it a step backwards to say that I have almost experience of about 14 years on the bench, and during which period I acted as a judge president for a period of 6 years. And should I get a nod, I'll be bringing a wealth of that experience in the SCA. And it must be recalled, as I had earlier said, that as the DJP, you carry a whole lot of responsibility in the court. When the record when you do your allocations, you've got to read all these records before you allocate to other judges. So you must be ahead in that sense to your colleagues. And when it comes to the bench as well, you must be ahead and you must give that judicial leadership to the bench. A matter that I have done both in the LAC and in the High Court. That is the experience that I would be bringing to the SCA. Is this judge a judge that would be able to hit the ground running? That's the question that we must ask ourselves. I may have referred to few of the cases in my questionnaire, but having been the judge of the LAC, if one was to go to the Industrial Law Journal, and that is not just merely a publication like SAFLI, those are law reports. I've got so many judgments where I have contributed immensely to the jurisprudential growth of this country from the Industrial Law Journal. Is that the kind of a judge that we should deny South Africans at least an opportunity to have them served at another level other than the level of the High Court? I would, in my view, say a no, a DP. And you look at my track record itself, is this the kind of a judge that delays when it comes to issuing judgments? This is certainly not the kind of a judge that delays in issuing of judgments. And from the law bodies, that has been made very, very clear that this is not the judge that would delay in the issuing of judgment. I can do no better than refer to the letter that was written by a senior judge of nomination letter, who sat with me in the LAC, who has also served in the Supreme Court of Appeal, and this is what he had to say about me. He says that Judge Phatshoane, my colleagues and I had the opportunity to observe her as we deliberated with her the issues. She's an astute jurist who is able to articulate the legal issues eloquently, who would participate in the debate. And when you look at other experiences that she has outside the judiciary itself, she's been a law teacher. She's been she has contributed to community-based projects, and that in itself, and many others that are mentioned in that letter. And it says that in itself shows some fulsome preparation for a seat in the Supreme Court of Appeal. And should we deny this country an opportunity to be served? Again, I would say no DP. And the other thing that must also be taken into account by the Commission is that if appointed, should I get a nod, it's not all is lost. There are other female or women judges in the division who would aspire to be deputy judges president, and who would like to be considered for those positions in future. If I were to occupy this position, I don't know for how many years, what would it entail for them? It means that they do not have an opportunity to advance. And for me, it would also mean I have not been accorded an opportunity for further development or for further growth because I had accepted this position. And would it not create some kind of a barrier to those who wish to occupy those positions? That might well be creating a barrier. Thank you, DP.
Thank you. You are, of course, aware of the provisions of Section 1673 of the Constitution, that the Constitutional Court is the highest court of the Republic, may decide constitutional matters and any other matter if the Constitutional Court grants leave to appeal on the grounds that the matter raises an arguable point of law of general public importance. So the proposition I want to put to you is that the reality is that in cases where that threshold is not met, the Supreme Court of Appeal would have the last word.
Indeed, that is so, DP. That is true. I agree completely.
And you would be aware that in the past 4 years, the Supreme Court of Appeal has lost 16 judges, either through retirement or elevation. Experienced judges at that, with a combined judicial experience of well over 300 years. Are you aware of that or not?
Yes, I am acutely aware, DP. I'm acutely aware of that.
And I take it there will be no dispute that at this point in time, the Supreme Court of Appeal needs, indulging in colloquial language, heavy lifters who can fill that void.
Indeed, it would require heavy lifters, and if you ask me, is Judge Phatshoane, can she qualify to be a heavy lifter? I would very much say indeed so.
And this will be my last question to you. So, given the attributes that you have articulated up till this stage, do you consider that you would be truly suitable for elevation to that court?
Indeed, DP, I think I would be truly suitable to be elevated to that court, as I said earlier, DP. I would be able to hit the ground running. When one has regard to the few of the judgments that I have included in my questionnaire, how I have articulated myself in those judgments, in all of them. Are those the kind of judgments, and I would ask the Commission to ask themselves the question, are those the kind of judgments that typically judgments that would be issued by a court such as the Supreme Court of Appeal? I would say, in my view, indeed, yes. And not only those judgments that are attached there, the judgments as well as that are not attached, that had been published in the other journals, the South African Law Journal, the Butterworth's law reports on labor and others. Yes, I would say I will be able to hit the ground running, DP.
Thank you, Judge Phatshoane, and thank you, Chief Justice.
Thank you, Minister.
Yeah, thank you very much, CJ, and good afternoon, Judge Phatshoane. My first question relates to a matter you have traversed upon with the Deputy President of the Supreme Court of Appeal. And I feel like you have not answered it in a manner that I would have been satisfied by now. Particularly the one related to whether if you are appointed as a Deputy Judge President to the Supreme Court of Appeal, will it not be a setback for the division and women leadership in the judiciary? I'm saying I'm not satisfied because I feel you answered it on the basis of your competence as a judge, going into the Supreme Court of Appeal, being one of the judges in the Supreme Court of Appeal, and not as a leader, which you are now in that division, which is the positive which this body is trying to help cue, and even the President has heeded a call for having women leaders in the judiciary.
I hear what you say, Minister, but I will still say I am of the view that where there is a judge that can fill a void. Remember what the DP was saying was that there's equally a void in the Supreme Court of Appeal, in that quite a number of senior judges had retired. And that void would also have to be filled somewhat. And here is a young lady, as the other law bodies are saying in their comments, very energetic and will certainly bring vibrancy at the SCA. She has made herself available, and one should not really close the door for her. Let her, develop further and move into the SCA. And yes, I agree that insofar as that there would be a move from my court to the SCA, ordinarily that position would have to be filled. And as I said, Minister, there are young women as well in that court who would graciously take the position. What I'm trying to say is that the court would not be depraved.
Yeah, I think for me, the issue is that with my little experience here in the past 4 years, what I have seen is that this body does play a role to bring women leaders into the judiciary. Because of the opportunities higher, the women leaders in the judiciary, they quickly move to the higher courts, whether as ordinary judges or as whatever position that might be there. And as a result, we then have the setback that the Deputy Judge President is talking about. What is your view to that? Do you think that it's beneficiary to the cause that the JSC is trying to resolve this challenge? And I think also there's a call in society that there must be leadership by women in the judiciary. When they are given the responsibility, within a year or two, quickly they move up for other responsibilities.
Yes, Chief Minister, as I had said earlier, I've been in this position for 6 years, if one has to take it from 2017, when I started acting as the DJP, because it has been continuous. So I've been in this position for period of 6 years. So it means others cannot really advance to be DJPs in that division. And it means that I am locked up in that position with no opportunity to move anywhere, despite the technical ability that I possess and skills that I can employ elsewhere in the country where it could be of assistance. I hear what you're saying, Minister, but I think I've responded to that.
Okay. On this matter of Kenton Trading and Fanti, I hope you still remember the matter. The
Fanti
DJP
Becker.
also, yeah, he also spoke about it a bit. But my question is different to his. I see it dealt with the issue that the issue of competency of the High Court to decide whether an arbitration agreement had come into existence or not. But you ended up concluding that the matter should be, it has been finalized at the level of arbitration because of that coming into existence. There is a school of thought that is beginning to emerge, criticizing the fact that complex commercial transactions end up in their majority being resolved through arbitration, and it then denies our courts to develop jurisprudence in this area of the law, particularly as per the section, I think it's section 3.2 of the Arbitration Act, which allows that to happen. What is your view to this growing practice of commercial disputes, anyway allowed by the Arbitration Act, ended up only being resolved through those processes and the country not benefiting through the development of jurisprudence because some of them are confidential and so forth? Do you have any view in that? If you don't, I will understand, but you dealt with this matter for sure. It might have pricked your mind.
Minister, what we do have here is the question of contractual autonomy. If the parties decide contractually that they would like to have certain of their disputes determined by arbitration, so be it. Somehow it brings, I would say there are pros and cons to that. There's advantages of these matters being dealt with by the higher courts, this commercial transaction, and disadvantages as well. Advantages in the sense that indeed we will get to gain a wealth of experience as judges of the higher courts in dealing with some of these complex commercial transactions that are usually referred to arbitration. But on the other hand, when one looks at our case laws as the higher courts, it relieves a bit of a pressure from us to at least have some of the disputes resolved through those other means, like the alternative dispute resolution process. In fact, our rules, Rule 41, try to introduce a form of an alternate dispute resolution process. So if we could have some of the disputes really resolve in forum like that, it would relieve the High Court of the pressure that's currently upon it. In that sense, I would say there's an advantage, but at the same time, contractual autonomy is also very important. We cannot dictate to the parties how they ought to regulate their private lives. Unfortunately, if they want to go the arbitration route, there's not much that really can be done. Our constitution is beautiful. It guarantees us all rights and freedoms, and including freedom to contract. And yeah.
So in that regard, how do we balance the interest of society, obviously, in terms of understanding that contractual autonomy and also the development of jurisprudence in this complex area of the law, which will be beneficiary for even future practitioners and generations?
Well, Minister, I wouldn't say that, the commercial work has been completely taken away out of our courts. We still do quite a number of commercial work in the High Court. I remember just the beginning of this year, I did a very quite involved commercial matter. I delivered a judgment there on the trademark law. As we know, intellectual property provides cumulative protection to the holder of that right. So cumulative protection in the sense that there were so many other disputes, although in one case that I had to deal with unlawful competition, copyright infringement. I'm just mentioning this by way of an example, infringement of the copyright and infringement of the Trademarks Act, just in that one matter. So we still have a lot of commercial work that we do in our high courts, including the SCA and the Constitutional Court, indeed, and providing that jurisprudence that's required by South Africans.
Thank you, CJ.
Thank you, Minister. Commissioner Marumwagai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Prof.
I have two questions for you. One is a bit more procedural, and the other one is more substantive. With the first one, I just want you to reflect on the test for special leave to appeal. What is the test? Because when one looks at the Superior Court Act, it makes provision for that route, but does not necessarily give the text. And the courts, the Supreme Court of Appeal itself, has crafted it, at least in 1986, if my memory correctly reflects. And subsequent judgments have repeated it repeatedly. So what is the actual test as crafted by the Supreme Court of Appeal of the special leave to appeal to that court?
The special leave to appeal would be whether the applicant would have reasonable prospects of success on appeal, and whether there are other compelling reasons really why the matter ought to be heard by the appellate court. The operative words there in terms of the test is the word would. You would remember that before the Superior Courts Act, the word would was not included in our common law and other decided cases. The Santa Melani, it will always, whether the other court may have reasonable, or whether the appeal itself may have reasonable prospects of success, but the operative words now is...
Sorry, Judge, let me assist you, because I think we don't have enough time. When you're dealing with leave to appeal, perhaps that might be the test, and the relevant provision in that act makes provision for that. But I'm talking about special leave to appeal. There is a particular provision. Yes, prospect of success should be there, but there is another special sort of requirement that you need to satisfy for the Supreme Court of Appeal to deal with that issue.
Yes, special leave. The other compelling reason, whether the matter requires an appellate court's attention.
Actually, there should be special circumstances which merit further appeal. But nonetheless, let's leave that. Let me go to the second question. I noted with interest the judgment that you penned at the Labour Appeal Court. And you were sitting with, among others, Davis J.A. at the time. It was the business rescue case. You referred to it earlier on. I'm not sure if you still remember.
Yes, I do remember.
And unfortunately, one of the councils there was one of the commissioners in this.
Yes,
In this
it
vote.
was Commissioner Nukaitobi.
Is it the one who's very quiet?
Let's just record that I won the case.
In paragraph 13.7 of that judgment.
Let me go to. Are you referring to paragraph?
It is on page 136 of the paginated bundle.
That would be which paragraph, if I may?
Paragraph 13.7. I mean, the main issue there was whether the business rescue practitioner could effect retrenchment without having placed the business rescue plan in place, and that was the issue that you dealt with. But I want to just deal with another aspect of the case.
Right, I'm
Page
listening, Commissioner.
137.
I'm listening, 13.7.
13.7.
Yes.
That's one of the grounds of appeal that were raised was in relation to the fact that Section 133, subsection 1 of the Companies Act, prohibits people or employees from litigating against the business rescue practitioner if those two requirements in the Act have not been met. One, consent. Two, leave of the court. But it doesn't, and the issue is when one looks at the jurisprudence of the Labour Court, there is this conflict in terms of which court must hear business rescue cases where labor law is implicated. In other words, where you are dealing with retrenchments that are affected by the business rescue practitioner. The question I want to ask you is Section 133.1 the starting point in these kind of cases? In other words, where the two exceptions, any of them have not been met, that then becomes the end of the matter? Or do you still proceed even if those requirements are not met?
I think we addressing that somewhere in the judgment. In that case, I remember that the issue had not really been dealt with in the Quarter Core. The question of the exclusion of jurisdiction of the Labour Court. It was raised for the first time on appeal, but nonetheless, we were of the view that when it comes to issues of retrenchment, Section 189 of the Labour Relations Act, it's quite clear what has to happen, and indeed, the Labour Court has an oversight role in terms of that, and ordinarily. The Labour Court would have jurisdiction to deal with disputes of the employees concerning their retrenchment.
No, sorry,
Or
Judge, I'm not
impending
talking about
retrenchment.
jurisdiction. I beg your pardon. I apologize. I'm not speaking about jurisdiction. The Labour Court does have jurisdiction.
Yes.
In fact, one can argue that it has exclusive jurisdiction.
Yes.
Because Section 210 of the Labour Relations Act is very clear. When there are many legislation that are applicable, the Labour Relations Act takes precedence. I'm not debating that. What I'm trying to get to you is the import of Section 133, the moratorium provision, which says that you cannot litigate against the business rescue practitioner and institute legal proceedings against them when those two requirements have not been met. One has provided consent. Secondly, leave of the court to litigate has actually been met. And they are raising it as an exception, as one of the grounds of appeal in 13.7, but you don't deal with this particular ground on your judgment. And I'm just trying to understand why.
There is, we do really deal with it in our judgment. If I may, to say that the court, firstly, the issue was not raised at a Quarter Core, and that the employees were, under the right to fair labor practices as enshrined in the Constitution, entitled to approach the labor court to deal with the matter. I think somewhere I do address it, as I'm putting it, Commissioner. I just have to get a particular clause where
No, in the interest of time, I will leave it there. But I think it is important that as you are going to the Supreme Court of Appeal, which is the court that deals with Chapter 6 of the Companies Act, that you familiarize yourself with the law around moratorium. I think that will do you very well. Thank you very much, CJ.
I didn't hear the question, the last.
Thank
last
you.
part.
I think maybe, Commissioner, you could just repeat the last part. She didn't hear it.
No, I was just saying that it is important, as the judge will be going to if appointed, of course, to the Supreme Court of Appeal, that she familiarizes herself with the architecture of Chapter 6 of the Companies Act and how the moratorium actually works. I think that will do her a good stead. Thank you very much.
Okay.
Thank you. Commissioner Dodovu.
Thank you very much, CJ. Good afternoon, Justice
Good
Phatshoane.
afternoon, Commissioner.
CJ, before my mind is locked, I just want to follow up the questions which were posed by the DP and the Minister. I'm doing so because I'm not clear in terms of what is it that we want to achieve in relation to your candidature. I'm saying this because in 2021, on the 1st of July, you were confirmed as a DP of Northern Cape. The same day, you were appointed as the Chancellor of the University of Sol Plaatje. And according to the evidence that you presented here, you basically served less than a year as a substantive JP, as a substantive DJP of Northern Cape, because you went to the SCA as well as the Labor Appeals Court. Now, I have this view that what is happening here is job hopping, and I want to clear me so that as I consider your candidature in this particular instance, that I'm wrong. This is not. It doesn't amount to job hopping, but it's an elevation in line with Section 174 of the Constitution.
Yes, thank you, Commissioner Dodovu. This would indeed not be a job hopping type of an exercise. And I say this again, I would repeat what I had said earlier on. I've been serving in this position for a period of 6 years. If I was not doing this in my court, it would be in the labor court. At some point, I was carrying this simultaneously, acting as DJP in the Northern Cape.
In the back of my mind.
Yes. So I've been doing this for a period of 6 years, and one has to look at my performance as a judge for a period of 10 years and ask oneself, is this not the kind of judge that has to serve in another court to make way for other judges to fill up the position at the
Justice Phatshoane,
yes,
with due respect, you applied to become the DJP of Northern Cape since 2016. And the 6 years you're referring to, you were acting. You were acting. You were not appointed substantively. And it was only 2 years ago that you are appointed substantive to this position. And as you know, Section 174 says the appointment of any candidate must reflect, one of the criteria is that it must reflect the gender and the racial composition of our country. And appointing a person of your caliber, of your stature, qualifications, and independent mind was a good thing. And I'm saying to you, it was only for 2 years, and in that 2 years, you only served basically for a year. And for me, that creates a difficulty, especially for a person who has waited on the wings for more than 7 years, even to an extent that you were acting, as you put in it. You were only confirmed about 2 years ago. And please clear my mind.
Yes, I was only confirmed
clear
2
my
years.
mind.
I was only confirmed 2 years ago.
Yes.
That's that. I can't take it any further than that.
Okay, thank you very much. Thank you, CJ.
Just a follow-up, but it was not confirmation. It was an appointment. First appointment as DJP. No, if you say confirmation, it's as if there had been a prior appointment that needed to be confirmed. It was an appointment. Is that right?
It was an appointment as
DJP.
Yes.
Yes.
Yes, CJ.
See, the question that has been posed to you by Commissioner Dodovu does raise with me the issue. If you were appointed as DJP in 2021 and before 2 years expired, or just after the expiry of 2 years, you want to move away from that position, is the position that from the time when you applied in 2021 for the position of DJP, you wanted to use it as a stepping stone to move to the SCA, or is the position that you wanted this position of DJP so that you could contribute meaningfully in that position as DJP in the Northern Cape Division? Because if you wanted to contribute meaningfully as DJP of that division, the question arises, if you have spent about, a year in the SCA and some terms in the LAC during that 2 years, it means that you actually haven't had a proper time to contribute as DJP, not as a judge of the Northern Cape, as DJP in the leadership of the division. That is the question that arises in my mind. What is wrong with me thinking like that?
Well, I'm saying this with respect, CJ, insofar as contributing to the leadership, that would not have been contribution of a year to the leadership of the Northern Cape. It would have been a contribution for a period of a solid 6 years.
No, Judge Phatshoane. Let's just stop talking to me about the prior years. They have a role to play. But in 2021, when you made yourself available to be appointed as DJP, there must have been something you wanted to achieve for the division in that leadership position. And the question that arises from me is whether when you have occupied that position only for about 2 years, about 1 year of which, if I remember correctly, you spent at the SCA, and some terms of which of the other year you have spent at the LAC, it can't be that you have achieved what you wanted to achieve in that position. So the question is it because did you apply for it because you wanted to use it as a stepping stone to higher positions, or is the position that you applied for this position so that you could be there for a certain period of time and make a meaningful contribution? That's the question that arises in my mind.
Yes,
And
yes.
I'm asking you the question, is there something wrong about thinking along those lines in the light of these facts?
It was not really a stepping stone, DP. I think I was invited to come and act at the SCA before I came, even before, I think before I came for the interview. So it was not really about a stepping stone into that position. I had already been invited. I remember that even when I attended my interviews here, the previous on previous occasion, a question was asked of me, Judge Phatshoane, one of the commissioners, when the commissioner heard that an invitation had been extended to me already to go act at the SCA. The question was, Judge Phatshoane, I hope that you next year, I think referring to the year 2022, I hope that you would not, was it a year, in 2021, in that year, the commissioner was asking, I hope that you would not be making yourself available in October when these positions are advertised. And my answer to the commissioner was that, Commissioner, you know, one never knows what the future holds. I cannot commit myself, but it was certainly not a stepping stone with that background, because I had already received an invitation to act in the SCA prior to the appointment itself as the DJP. I hope that allays your fear.
Well, you see, I'm now thinking, you came to this body in 2021 and asked to be appointed as DJP. About 2 years later, you want to go somewhere else. If we advise the president to appoint you, you will go to the Supreme Court of Appeal. Somebody else will come to this body and ask to be appointed to the position that you currently occupy. Maybe that person will do the same. Within 2 years, they want to go somewhere else. The question arises whether there shouldn't be some time when, if you have been appointed to a certain position where you stay and there is some stability before you move on. The next person might just also do the same, and then we have no stability. Of course, nobody says if you accept one position, you must stay in that position forever. Nobody says that. But it's a question of having some stability so that you make a contribution and make a difference of the opportunities that come with that position.
Perhaps that's an issue that this commission might have to look into in future, because as it stands now, it appears to the other judges who may be aspiring to be deputy judges president, that it might be a barrier. Perhaps maybe if a period is set by the commission for all the positions really in the judiciary, that one would have to stay in a particular position, then at least we now know. But otherwise, as it stands now, it appears as if one would have to be in this position, and one never knows for how long. How long would it then be concluded at some point in future that a particular judge has sufficiently worked as discharged the responsibilities of the office of the, attended to the office of the.
So if we leave out the time you spent acting in the SCA and the time you were acting in the LAC between beginning of 2021 and now, how much time have you spent in your division as DJP?
I think it's probably 2 years now, DP, because now we have to calculate this year as well, I've been in my division
Which month were you appointed as DJP in 2021?
in 2021. I stand to be corrected here. I think it was July. Yes, July.
July 2021?
21, and then it goes to July 2022. It's more than 2 years.
Yes,
and
but
some
didn't you say you spent about a year in the SCA?
Yes, in 2021, I was in the SCA
For about a year?
for 3 terms.
Yeah, that's 3/4 of a year. And how many times were you in the LAC?
No, I was not at the LAC. I was back at the SC at the SCA in April again. I think
In
that's
April this
second
year?
term. No, last year.
Yeah, but you said it's three terms.
3 terms.
So that means you have been in this position for 1 year, 3 months, or 4 months, or thereabout. That's what it means after appointment.
After appointment.
Am I right?
Well, it may well be.
That means you have been in that position of DJP, actually working as DJP in that position for 1 year, 3 months, or 4 months after appointment.
After appointment.
Am I right?
That would be correct,
Yeah.
CJ.
Okay, all right. Commissioner Nyambi?
Thank you, CJ. Afternoon, Judge Phatshoane. I'm here.
Oh, Commissioner.
The comments by LSA, you have seen them.
I have.
If you consider them and the hindsight of the discussion with the DP, the CJ, Commissioner Todovu, and Minister, don't you think there's some element of truth in it?
No, with due respect, with all due respect to the Law Society of South Africa, if one reads their comment, really, it's truly amazing that a body like the LSSA would make such a crucial mistake, because what they do say is that Judge Phatshoane presents as a very strong candidate, but unfortunately, she has never acted at the SCA at all. Truly, it means that they did not read their papers. They did not, with respect to them, even read the judgment, because they would have picked up, having read the papers, that there were even judgments that she penned while she was at the SCA. There, what they say is, I've never acted at the SCA at all.
The part that I thought maybe after the reflection, because of the benefit of the engagement about the issue of your permanent appointment, the minister, when I was asking that question, you indicated that you want to open space for another person, and the likelihood is that it might not be a woman, because it's not given that the next DJP, if you can be appointed, it can be a woman.
True.
It means, in a way, we might be reversing the gain that we have made to have you as a DJP in that division, because the leadership position. Then my last question to you, anything that you might consider as your weakness that you think if you can go to the SCA, it might need some immediate attention? Your weakness, because I know your strength, your hardworking, your technical competence is not an issue, but what you might consider as a serious weakness, if you are honest to us and share with us what you consider to be a weakness.
I must think of this. I think my weakness probably will be being too meticulous. it's if one is too meticulous, I don't know whether one can say that it's a strength or a weakness. Some people will perceive that as a weakness. That,
It
that
can't
you are
be a
too-
weakness to be too meticulous.
Well, some may perceive that because you tend to.
You don't know your weakness.
You worry a bit about. I'm a perfectionist. Sometimes being too perfect, it's a problem. Particularly when you attend to your work, that being a perfectionist, it might be perceived as a weakness for others.
Are you sure is that a weakness?
True.
I think.
Thank you, CJ.
Thank you. I think what Commissioner Nyambe is trying to establish is what you regard as your weakness. Forget about what other people say. It's a struggle to find it.
It's really a struggle. I'm struggling to find what that's something where
Okay, all
that
right.
area where I could be said.
Commissioner Nochesi.
Yeah.
Thank you, thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Yeah, part of my questions have been covered, but I do take it from there where they've left the Chief Justice, Deputy President, Mr. Nyambi, and other commissioners. I just want to hear from you. What do you regard an appointment to the SCA? Would you regard that appointment as a promotion, or you say you want to go to the SCA because there is a particular contribution or value that you will add?
Indeed.
So I want to know why I'm asking so that you answer two questions. You have been applying ever since 2016. You have never ceased to apply. Whenever there's a position, you apply. Well, and I'm worried that next year, if a position in the SCA is advertised, you will apply. So I want to understand you. What do you understand? What's your understanding of this appointment? Is it a promotion or an opportunity to serve?
It is an opportunity to serve.
Yes.
It is an opportunity to serve a commissioner, not really a matter of a promotion. What I try to do is to place before the commissioners my experience as a judge over the years, and to say, here am I. I'm making myself available to serve in the Supreme Court of Appeal. I am of the view that, but it's not really about a promotion. No.
But what is it that is unique to you, which you say, I apply to the SCA to bring, which you cannot do as a leader of the judiciary, because you are appointed as a judiciary as part of transformation, as part of gender transformation. That's a specific. And that is the very reason why, when you appointed, those are key things that are taken into account, as Judge President says, that look, there's a shortage of women in the judicial leadership. Now we abandon that position. You say, no, I don't want this one. You have given, I'm leaving it. I want a position there. Say, what is it that is unique that you are bringing to the SCA to an extent that you will abandon the Deputy Judge President position?
What is that I'm bringing
Yes.
that's unique to the SCA? You must remember, Commissioner, in the SCA, we get to determine disputes that would not ordinarily be determined at the level of the High Court, in a sense that when leave to appeal is granted, so there must be compelling reason why the matter has to be heard by SCA, and I am of the view that I've got the intellectual skill, technical ability to be able to deal with matters at that level. The High Court, yes, we do hear matters, and there are, at times, we do get quite challenging matters. One cannot say that there's really, judging is judging whether you are at the SCA or at the High Court.
Yes. Yeah, look, this is bring to my last question, Sir James. Sorry. This brings me to this question. What is your judicial philosophy that distinguishes that to say, as I go to the SCA, this is a dimension, this is a diversity in this court that I'm bringing. What is your judicial philosophy?
The former Chief Justice Pius Langa, writing on transformative constitutionalism, one of these Stellenbosch journals, he talks of a historic bridge. The historic bridge that is characterized by the past, where we come from, where there's hardship, inequality, and the future in the open and democratic society, where we have in the open and democratic society, where you would have the economy and the social aspects of it having to be looked at critically. It is a project, and it entails a very it's a difficult task that's facing us as judges, in order to ensure that the people of this country in the end enjoy the full and equal enjoyment of their right as set out in Section 9 of the Equality Clause of the Constitution. Judicial philosophy. We are called upon when looking at transformative constitutionalism itself, that when we have to interpret the law, we look at the Constitution itself, and when we interpret the law, you must look at those values that underlie the open and democratic society based on equality, freedom, and respect for human dignity, taking into account the international law, and taking into account the foreign law. It is difficult really for one to define yourself, because judicial philosophy talks to a particular type of a judge. I've heard that in some instances, people would refer to the so-called activist judge and conservative judge, and a question would be asked, but what type are you? But in our country,
having... You don't want to pigeonhole yourself? No, thank you very much. You have answered my question.
Thank you.
You don't want to pigeonhole yourself.
Thank you, Commissioner Singh.
Thank you very much, Chief Justice. I'm going to be very brief, because I think my line of questioning is the same as all the other commissioners on the period.
Yes.
But let me just say, having said that, there's no gainsaying, Judge Phatshoane, that your ability, technically and otherwise, is recognized by all of us. And that is why the JSC appointed you as DJP, a very high position, not even 2 years ago. And where I want to agree, Chief Justice, with the judge is that perhaps we as a JSC need to look at appointments in the future, and whether there should be a capping, a period within which somebody has to serve in a particular appointment before they are promoted or go sideways. I think it's something that we have to discuss as a commission. But my one question would be to you, Judge Phatshoane. Do you feel that currently you cannot add more value to the position of DJP in the division where you are appointed? Because when you came here 2 years ago, you had lots of ambitions, a vision and a mission. Do you think you've fulfilled all that you said to us here 2 years ago? And you feel you've done enough there and you want to move on or move sideways or whatever?
Commissioner Singh, the question that you asked, did I add value by having been appointed there? Indeed, I have added
No, I'm sorry.
Yeah.
What he's asking is whether, bearing in mind what you told this commission you wanted to do when you were interviewed, is the position that you think you can no longer add value to that position as DJP?
I can no longer add
Yes,
value.
yes.
Oh, is the negative, the converse. Commissioner, let me put it this way. Wherever I am appointed in this country, I will continue to say I will add value wherever I am. I cannot say to you, frankly, I think I've done what I had to do in the Northern Capes and I won't add value. No, I absolutely would not say that. Anywhere where I'm sent in this country, I will add value. I can never stop adding value to any institution.
So can I then assume that you are saying it's mission not accomplished as yet as DJP? Will I be correct in saying that?
No, I think you're putting it the other way to say mission not accomplished. No, I think the question was, would I? No, Commissioner. I think wherever I'm sent to, I will continue adding value. Did I accomplish my mission? One never knows when the mission is really accomplished.
Chief Justice, could I just follow up this discussion?
Yes, sure.
Maybe expand it.
Yes.
But before I do that, Justice Phatshoane, the criticism that you did not address the issue of the Section 133(1) of the Companies Act in your judgment is in fact not a fair criticism, because at paragraph 16, 17, 18, 19, and of your judgment, which appears at 136, 137, and 138 of the record, you actually deal with it
Yes,
extensively.
Extensively, I agree.
Yeah. So, I mean, I just don't want an impression to be created that you overlooked a critical point that was raised by the respondent.
Yes, like I indicated, Commissioner, and thank you for bringing the particular paragraphs to my attention. I knew that we had dealt with the particular issue of jurisdiction in that judgment.
Yes, in fact, you rejected it because it had not been pleaded.
Yes, thank you.
Which is a legitimate basis to reject a point.
Thank you.
Now, the point I wanted to ask you about is, yes, that was my argument. But I think for our purposes, the fact is that you dealt with it.
I have that.
Yes, thank you. But the point I wanted to just discuss is it's this issue around transformation, and there's some sense I'm getting from some of the commissioners and the questions that are being raised that, look, we have a choice and the choice is binary. You are either a DJP because you have not been there for long enough, or you are in the SCA. And that is projected as a problem for transformation. I think you get that. You get that?
Yes, I hear what you're saying.
Yes, that's I think is the debate. But there is another way of looking at it. I mean, that in fact transformation has got multiple shades.
Yes.
And that your entry into the SCA is also transformation.
Indeed.
And your departure in the Northern Cape, if you are replaced by another black woman, is also transformation.
Indeed.
Yes. And so that, for me, is what causes me anxiety in presenting this as a binary, that we have to put you either as DJP, and we must keep you there for a period that is arbitrary, that we must decide on an ad hoc basis, or put you in the SCA. And it seems that the deeper problem is an institutional problem of a critical mass. We just don't have enough black women in the judiciary. And we just don't have enough black women who can become leaders as DJP or as presidents. And that's a different problem that has very little to do with you. And so it seems that we need to look at your own candidature and whether you fulfill the requirements of the SCA or not, rather than impose the obligations of transformation on you as an individual, absent the context. And one can think of a range of these examples. Somebody says, I want to be the president of the SCA, but I've got 2 years left in the judiciary. You know, sometimes we appoint them. Or someone else says, I want to be a judge of the SCA, but I've got 3 years left before I reach retirement age. And we appoint those people. So that's what causes me some anxiety in this binary discussion and the imposition of these obligations on one candidate, which is in fact an institutional problem of the critical mass. So I wonder if you want to reflect on that, because I thought you were conceding too much in the exchange with some of my colleagues. So do you want to comment on that, and maybe whether I'm right or wrong, or whether maybe you don't want to comment? But I just thought maybe you should debate the point.
I couldn't agree with you more, Commissioner Ngetobi. I mean, for me to move further, be elevated to the SCA, having regard to my track record, is it fulfilling the transformation mission set out in the Constitution? I will absolutely agree that certainly it's fulfilling that. And if I leave for the SCA, what happens in the Northern Cape? The Commission indeed would have to relook into the situation, and it's also a transformation issue. Who do they appoint there? Are they going to fill up the position with a female candidate? What's going to happen? The issue of transformation, Commissioner Ngetobi, is a project that has a myriad of issues in it. The concept in it lying underneath there. And one of them would definitely be the although it's just an aspect of it really, the appointment of or consideration of gender, issues of gender and representativity of the female judges in the echelons of the judiciary. But I will most certainly agree with you that it's a transformational issue if I were to be appointed at the SCA.
Yes. Now there is a
Can I just
different.
follow up on that
Yes.
before you
all right.
carry on?
No. I just want you can
Yeah,
follow
okay,
up on this point.
let him finish, and then you can come in.
Should I finish, CJ, or should?
Yeah, finish first.
All right. Yes. Now that of course is separate from your own individual merits for the position, and that's where I want to end, because you were asked by the Chief Justice right at the beginning to help us draw a distinction between the two types of discretion: judicial discretion, not administrative discretion. Now, which you did, but you were still unclear about whether or not you grasp these two types of discretions. Let's start with the first one, which is the discretion in the true sense. Sometimes you call that a narrow discretion, and you identified the correct judgment. Just explain what is that discretion. Don't talk about how an appeal court should deal with it, but what is it? In other words, how do you know that I am dealing with a discretion in the true sense, Trancon sense? What do you look at in the statute? And contrast that with a discretion in the loose sense, sometimes called a wide discretion. What do you look at when you are considering it? And I remember the Chief Justice became a bit frustrated when he was trying to draw from you your analysis of what an appeal court might or might not do. And I felt uncomfortable that I got the sense that maybe you know the answer, but you're not explaining it. So just tell me one sentence, what exactly is a discretion in the narrow sense or a true discretion?
Okay, discretion in a narrow sense would be where the court has to consider when exercising a discretion, it would be having a variety of choices that it has to make in the exercise of
Yes,
the
no, but
discretion.
even a discretion in the loose sense also involves a variety of choices.
Yeah.
The difference lies in those choices. That's what I'm trying to understand. What exactly is it?
Yes, the choices, the difference in the choices. Let's go to the one in the loose sense. I've given.
No, let's first deal with the one in the true sense.
Yes, the one in the true sense,
Yes.
like the issue of costs.
No, don't give me an example. Give me a description, a definition. And it's in Trencon because you identified Trencon. Now, what it says is that a discretion in the true sense is where you have an option between two or more acceptable options. And the judge chooses one option. The Court of Appeal is not entitled to say you should have chosen
interfere.
option B. So, yes. Now we go to the discretion in the loose sense or the wide sense. What exactly is that?
The discretion where the judge does not really have much of a choice or much of options.
Or in fact, wider options.
Yes, yes.
And then the Chief Justice also tried to press you to explain what the role of a Court of Appeal is or what the powers of a Court of Appeal are. Now, even there, I got very confused because I got the sense that you were not, if you understood them, you were not explaining them properly. Now, what is the role of a Court of Appeal in the true discretion?
That would be in the narrow sense.
Yes.
Yes, the Court of Appeal would usually be restricted or constrained to interfere there.
To defer.
Yeah, to
And
defer.
then there are circumstances it may interfere.
Yes.
And what are
indeed.
those?
Where, for instance, the judge did not exercise his or her discretion at all, then the
Well, I mean, he has exercised the discretion. That's why the case is on appeal.
yeah.
And then the second point the Chief Justice also got a bit uncomfortable was this issue of whether you understand a discretion in the loose sense. And and Trencon also answers that question, and it says, there the Court of Appeal is in the same position as the judge a quo, and it has no duty to defer, although it has to be careful.
It
But
has to
is-
be careful,
yeah,
yes.
but it is in the same position as the judge of quo. Now that's the problem I was having, that you are now going to become a judge of appeal. And this topic about the discretion of the court judges is regular. It will feature all the time. And that's why I become uncomfortable when I don't get the sense that you are actually on top of it. Thank you, Chief Justice.
Thank you. Commissioner Steinberg.
I also had a discomfort at the direction the conversation was taking, in that it might be interpreted to mean that there is further prejudice to women in the position of leadership at the high courts, in that they must stay there and not be elevated to the SCA, so that there can be women heads of court, which then would prejudice that person. Whereas a man in that position could be promoted because the transformation issue doesn't arise as acutely. To me, the pertinent issue here is the length of time. Whether you were a man or you were a woman, the length of time that you've served actively as a leader of that court is really very short. And so therefore there is a question about your commitment to serve as opposed to your ambition to be promoted. To me, that's how the issue should be framed. I don't think you should be held longer in a position because you're a woman. And I agree with Commissioner Ngubatobi that the real issue is your qualification for the job. And I must agree with him. I'm also concerned about your grasp of the law and setting precedents as a judge of appeal. It's concerning to me that you didn't include judgments that were just written as you as a single judge.
That I did,
You did?
yes.
Which ones are those?
In the questionnaire, there's, I think, the last,
You attached.
yes, I did attach them.
Are you correct? You attached that is one judgment. It's very, very difficult for us to
It's
assess.
two of them.
Two. Which are they?
Those were the judgments of the High Court. One is the one is on the confiscation in terms of the
NDPP.
Section 18
Yeah.
of the Prevention
Yeah.
of Organized Crime Act.
Yeah.
And the last one is it's a judgment, State versus Sitolo, which deals with corruption. And there's also a judgment in those judgments of the SCA where I had actually penned a dissent, and that would be a judgment where I stood alone.
I stand corrected. You did include two. I didn't find them sufficient, and I did some Googling.
You didn't find?
That's sufficient. Those two judgments, to me, were not sufficient to assess your ability as a judge, writing on your own, plus the dissent. And, you know, I saw, for example, a matter that went on appeal, CCMA versus MBS Transport and Becker Management. And there, you know, there is no issue per se of an appellate court overturning the
Indeed,
judgment of a
yeah.
lower court. Per se, I think that should and must happen all the time because judges can differ as to interpretation. It's what's overturned and how. This one is very sharply overturned. The court says, I fail to understand the quo quo's reasoning at all. Section 145.3 is clear. The enforcement of an arbitration award may be stayed by the Labour Court. The section has no qualification or limitation, and yet you saw one. Now, that is a very basic error to have made. So what I'm putting to you is, looking at the way you have dealt with the legal questions that have arisen here, and the little bits I've been able to see of you writing on your own, I'm not persuaded that you're qualified to be a judge of the Court of Appeal, writing precedents for the high courts in the country. And perhaps you might want to respond to that.
Yes, thank you, Commissioner. As I had said earlier, I have written plethora of judgments in the Industrial Law Journal over the years. I mean, they are reported there, and that deals with the jurisprudence that increases the jurisprudential growth of that court that had been referred to and cited with approval by the other courts, but coming to your question again. I've tried, you know, with the judgments that I have attached there to show that, I mean, all the judgments that I have attached there, that when one reads them on their own, let's leave the judgments of the Supreme Court of Appeal aside. Really, can one say that the judge has not contributed to the jurisprudential growth of this country? And I just want to refer to the Canton matter. at the SCA, and I'm going to also refer to the other judgment that I had penned there. In the Canton matter, when I penned that judgment, I must say that at that stage, the majority was going the other way, and when my judgments came out, we were 2 poles apart, and immediately after issuing my judgment, it sort of the focus had to change somewhat to relook into the judgment. I went further on deeply into researching which were not basically not attached to the papers before us. What is exactly that the Arbitration Foundation of South Africa rules provided, and out of that, I mean, one comes to a conclusion that really an arbitrator himself could not, or could rather, or was in a position to determine the issue of jurisdiction of its own jurisdiction. But I also want to refer to the other judgment that I penned to when at the SCA, which it's not attached to the papers. It was purely a factual matter, but where my colleagues would agree that look, I mean, the colleague presiding in that matter had actually said to me that, look, I had penned a judgment on my own, and my colleague then said, look, I mean, I agree with you with the judgment that you had written, but I would have liked to and I want to just to use the precise words he used. He said, I had the opportunity to read your judgment, and upon reflection before that my approach, although having much in common with yours, you see, although my approach has much in common with it also differs somewhat, in other words, moderately, and therefore I would wish to have a separate concurrence on this. But ultimately, in the end, we had to agree, having had that separate concurrence, that one judgment had to be written. So I am of the view that I'll be able to get into the SCA and hit the ground running, not only because of this and because of my other experiences as having been, served in the LAC, and I've referred earlier to what the judges of that court had to say about my technical skill, my technical ability. And these are senior judges who speak boldly and very well of my technical abilities to serve, or having served with them as a judge of an appellate court, which is quite no different really to the Supreme Court of Appeal. And I think I've said what I could really.
I do hear you. I think my concern, maybe narrower, is when you answer at 16.1 and 16.2 of the questionnaire about significant cases and which have been reported. There's only one reported judgment where you're not part of an appeal panel.
There's only
one reported case, the Scholz case, where you're not sitting as a court of appeal.
Yes, and there's also the Setolo one, the last one, where I'm
Oh,
not
I
sitting
didn't
as
turn
a
the
court.
page.
And there's also
those are the two loan judgments.
Because it must also be recalled,
Sorry,
Commissioners-
can I just
Yes,
finish?
Thank you, sorry.
Any High Court judge who sits for years would have written many, many judgments that are published on SAFLI. But it's reported judgments that count when you're applying for the SCA. Because reported judgments are those that deal with novel points of law, developments of law, precedents. And there is, my point is that there is little to show that in your own right you've engaged in that kind of thinking and judgment writing, just in terms of your own questionnaire.
May I come in? Thank you, Commissioner. As I said, if one looks at the questionnaire, it says list the cases where you have not more than 10. You cannot go way beyond more than 10. And when you had been in various appellate courts, you would try to sample. Particularly here, I was at the SCA. I will try to give more judgments from the SCA to see for the commissioner to see for themselves. Is this the kind of a judge that would write a judgment at that level? And one appreciates that when one writes in a court like the SCA, there's quite a lot of contribution to some of the judgments or whichever way. But not only that, I mean, I've also served in the labor court. I've tried to put some of the judgments there. I've also served in the LAC. I put some of the judgments there, and two of my judgments in the High Court, constituting 9 judgments there, because we cannot go more than 10 judgments in our questionnaire. If we were to be given the latitude to put all the reported cases that one had had in the legal career that were reported, as I said, some reported in the Butterworth's law report, some. One would have put that list on the questionnaire itself, but it is limiting. And
thank you, Commissioner Moyman.
Thank
You have not been covered as yet.
Yes, I've been covered, but just one aspect.
Okay, all right.
Particularly coming from that province. The discomfort that one has in relation to the views that were expressed by various commissioners, I guess relates to failure on your part to articulate to us in terms of succession planning as part of the judicial leadership attributes that you articulated so eloquently in 2021, because a rural division is always a challenge in terms of recruiting the best of the best. The rural High Court divisions, like the Northern Cape, whether it's Limpopo, whether it's Mpumalanga, particularly at leadership level. So the question that I want to ask and pose to you is, as part of the leadership of the division, yourselves and the JP, is there succession planning in place, taking into account the fact that there are only 7 permanent judges on the bench, and so therefore the question, what one would have expected from from DJP is just to put our discomfort to rest, to say, in terms of the profiles that we have at the division, this is the situation, so that we are able to take a proper decision when it comes to deliberation. Thank you.
Thank you, Mr. Muima. The question is there proper succession planning in place? Perhaps maybe with the judiciary, it's difficult to have a succession plan because this body affects the appointment of judges, and you can't say a particular judge will be the next one in succession. That is left entirely to this body to decide. But in terms of the number of judges appointed in that division, particularly women, we've got one white woman judge. We've got, including myself, 2 African women judge. We've got 1 colored woman judge. So it's about 4 women out of 7 permanent judges of that establishment, and 3 are men, 1 white male, and 2 black men. So there are a sufficient number of women at the moment, at least 3. Should I leave? Should I get a nod? There would be 3 available. Whether they would make themselves available is I cannot, in light of the sort of barrier to being a DJP position, and I agree with the Commissioner Gaitobi that it's something, and Commissioner Singh as well, something that this body would have to look into in terms of criteria that would have to...
We can't hear you when you speak so softly on this end, yeah. We still want to hear what you're saying.
I was saying, I don't know at what point Chief Justice did not hear, but in terms of the succession planning, I was saying that it's difficult to...
Oh, no, I heard that part. It's just the last 3 sentences, I think, that I didn't hear.
Oh, okay. I was saying, as Commissioner Gaitobi was saying, and Commissioner Singh, the commission would have to look into introducing some kind of a time frame within which or a term within which a particular judge would have to serve in a particular position, other than subjecting a candidate to a criteria that at the moment we don't even have in terms of the time period that one would have spent in a position. Thank you, Chief Justice.
Thank you, CJ.
Thank you. I think we have, oh, yes. Maybe before Commissioner Baloyi puts a question, maybe I should just say to you, the questions that I asked you about you having spent a relatively short time in the division as DJP, if you were going to be appointed to the SCA now, are questions that I would ask a candidate in a similar situation, even if it was a male or a black male, white male. So it's because one aspect is about transformation, but another aspect is about stability in the leadership of a court. If in any organization there are frequent changes in leadership, you won't have stability. So I would be concerned about frequent changes or too frequent changes in any organization, irrespective of whether it's a male or a female, black or white, but obviously in relation to, in certain circumstances, there would be the additional issue of transformation. So I just thought I would explain that so that there is clear understanding that certainly there is another element, namely the operational as well. Thank you. Commissioner Baloyi.
Thank you, CJ. Good afternoon, Judge.
Good afternoon.
Yes, maybe just to preface what I'm going to put to you, that I also do share the concerns about your duration and that you would possibly be elevated when you've spent so little time in the division. But the purpose of what I'm doing now is simply to put to you that this very topic that clearly from this discussion is a matter of concern has also been highlighted as an issue. Well, I say issue, but it's been highlighted by the SA chapter of women judges, who, while commenting about your ability and saying all positive things, they make the note in emphasis that the commission should note, and I read, commissioners should note that the candidate was appointed as a Deputy Judge President of the Northern Cape in July 2021 and therefore has been in that position for only 2 years. So that is highlighted and appears to also be a matter of concern to the Women's Judges SA chapter.
But
I know you've debated it, you've discussed it. I'm really not asking, I'm just putting it to you that they seem to have flagged it.
Yes, but they seem to be supporting my appointment.
Yes, I've said that. I've said while they support and commend you to appointment, they note this and quite in bold in the way that it's put here, that it is an issue to be considered by the Commission. Thank you. Thank you, CJ.
Thank you. I think we have come to the end of the interview. Thank you once again, Judge Phatshoane, for making yourself available. We appreciate that. We have come to the end of the interview. You are now excused.
Thank you, Commissioners. Thank you, DCJ.
Thank you.